Hi, and welcome to the Plan Sponsor Playbook. I'm Brad Ferguson, Chief Executive Officer of SWBC Retirement Plan Services.
And I'm Sara Matlock, SWBC Retirement Plan Services Senior VP. Let's take you through the 3 F words of the retirement space: fees, fiduciary, and fear of litigation.
We're here to help you create a playbook to defend yourself against the increasing scrutiny of a plan sponsor's fiduciary duties with respect to their retirement plans.
We want you to understand your fees because it's not just best practices, it is actually a legal requirement.
And the fear of litigation is on everybody's mind.
So we're going to take you through a winning playbook to help you master your retirement plan.
So, Sarah, how can plan sponsors stay compliant and safe?
Well, really, to answer that question, you have to step back and understand that the way that retirement plan fiduciaries are structured is very faulted. Not to be too judgmental, but in every other aspect, a fiduciary is somebody who is legally and ethically responsible for another party. And they have rigorous training, advanced degrees, they have to do continuing education, the list goes on and on. But here, in very stark contrast, somebody who has expertise in an alternative field is now thrust into a situation where they have to have investment oversight. Who has the tools or skills to do that? They have to be basically an expert in retirement plans, and most of them aren't trained to do that. So in that, if they don't have the expertise and they realize that, then they're required to actually hire an outside person to handle that. But that is not where their responsibility stops. They then have to go on to monitor the person they hired and do due diligence on them. It is a very overwhelming process. But to stay compliant and safe, they really need structure, discipline, and documentation.
Right. So let's have a couple of examples there. Is there anything specifically around those things that you're talking about?
Sure. So and when we talk about structure, discipline, and documentation, we are always talking about preventing lawsuits. That is always the biggest fear. But we're also talking about what the DOL and IRS really expects, because it outlines in ERISA that you have all of these things documented. They want to see how you're managing your investments. They want to see how your plan's structured and that you're operating in accordance to all of those things. So again, it really goes back to those 3 key words: structure, discipline, and documentation. And that doesn't mean you have to document every single word. You want to document how decisions are made. And that is really the key. And that is what everybody's looking for when they come in and look at your plan.
So is there a real situation where plan sponsors are going to find themselves in a situation where they need to defend themselves?
Yes. Litigation is on the rise. We've just made it so it's easy to do. And litigating attorneys have found that this is a place that they can really gain traction. One of the tactics that we are seeing, we just saw it with Swiss Re, is they give a laundry list of different issues the plan's having. So they don't just go in and say fiduciary oversight. There's so many different aspects of the retirement plan. Fiduciary responsibility and fees are still the number 1 target, but we're adding to that forfeiture and all sorts of other oversight aspects. And we haven't seen how this works out yet in this particular case, but what we're thinking is they're hoping that if they say enough, that it all won't get dismissed at the beginning. They won't have the documentation and the processes to dismiss it at the beginning, and they will be able to move forward with the case.
Sort of that approach. We'll just throw everything against the wall and see if anything sticks.
So with this case, they had excessive record keeping fees. They had imprudent investment decisions, misuse of participant data, which is one of the newer ones, where we saw that actually the record keeper was pulled in because they were cross-selling to the participants. And on both sides, both the record keeper and the plan sponsor, they had breach of fiduciary duty. So again, it was one of the longest lists that we've seen, and it'll be interesting to see how it plays out.
Yeah, and I think I'll come back to that on fees a little bit later, but I know we have a checklist that we use with our clients. Talk a little bit about that. What does a checklist look like for a plan sponsor who's trying to get ahead of some of these things?
Sure. Well, again, it all comes back to that structure. because the structure is going to be really that roadmap, how everything is set up. So we do work with our clients to make sure that our advisory agreement, make sure we stay on the same side of the table if something does come up. We also make sure that there's an outline for their investments, and the same goes on their administrative side, that they have a clear understanding of how their plan is written. Because if you don't understand how it's set up, then how can you make sure that as we go through the processes that we do exactly what we say we're going to do? In addition to that, it really takes the pressure off the fiduciaries if it's all set up correctly and they have people that come in and really handle it for them. We tell our clients our goal is to make their lives easier. This is a hard process that puts a lot of responsibility on them, and they are actually personally liable. So we want to come in and do everything we can. We're all in the boat together, but we're going to be rowing really hard. So that's kind of how we structure it.
Yeah, and I think that's why active due diligence and management is every plan sponsor's first line of defense, right?
Absolutely.
There's all of these threats kind of out there. It's not just sponsor a plan and off you go, right?
Right.
It's being aware and having that active management. SWBC is a fully independent firm, and I think it's important to have that specialist at your side that doesn't have a vested interest in anything except acting in the best interest of that plan sponsor.
Yeah, we do take the conflicts of interest seriously. I mean, not even letting somebody buy us a cup of coffee. Something that I think is important and that we can really stand behind.
For sure.
So Brad, let's change topics just a little bit. What are you seeing are some of the must-know management tips for avoiding some of these litigation and some of these newer situations like forfeiture accounts?
Yeah. So with forfeiture accounts, first of all, forfeitures are you've made an employer contribution to a plan, then an employee leaves before they're fully vested. Those funds come back to the plan. So I'd say the top three things are, number one, knowing what are you legally able to use those funds for. There's very specific guidelines that ERISA says what you're allowed to use those for. Second piece is knowing very clearly what are you in fact using them for. There's with a lot of different ways you can use them, whether it's paying for plan fees or reducing your employer contributions, whatever you're using them for, just having that real confidence of what you specifically are doing with them. But then the last piece, and this is where the litigation has come in, is what does your plan document say you're going to do with those funds?
So different plans. So if you were maybe an HR professional at one group and switched to another, your rules now might have changed.
Right, because just because the law says you can use it to offset plan expenses doesn't mean your plan document says that that's the first thing that you're going to do with those. So that's where the litigation came from. It said, all right, we're going to use it first to reduce our employer contribution, and if there was any left over, we would use it to reduce expenses. But that's not what they were doing. So if they weren't specifically, even though they're using the forfeitures in a legally permissible way, if that's not what your plan document says, as far as the hierarchy of how you're going to use it, that's where they got themselves in trouble.
Yeah, and I think some of these situations too, where they're really wanting that best practices of using it within 12 months. And I know that a lot of our clients have a lot of rehires. So those accounts bump up very quickly. So having a strategic plan of when to use them could really help, I would think, offset that.
No doubt.
So what are some red flags really that have been the target of litigation, some additional ones?
So red flags is such a broad term, right? Anything can be a red flag. When you're out there and you research 5,500 forms, those tax forms that every retirement plan has to file, and they're public documents, you can go and you can search through databases. And I've had some of our clients come to us, I know you've had the same, Sarah, where they say, oh my gosh, we have 6 red flags. We have 8 red flags according to this database. And I said, well, one of them is that you don't have target date funds. Or, for any plan, they pull out all of these things that could be a red flag. But for any one given plan sponsor, there might be a very specific reason why they don't have that specific thing. A red flag, I don't have auto enrollment. And so a client that I have that doesn't have automatic enrollment, they don't have it because they have a very high turnover rate and they don't want to have to deal with all those small balances and getting in there and then having them returned. And so they had a very specific reason for not using it. So red flags aren't necessarily a bad thing, but certainly, there are red flags that are very concerning. And I think where we want to talk about is the ones that are concerning, and it comes down to lack of process. If a plan sponsor doesn't have a reason for getting to where they are, That's the problem. It's not necessarily about where you ended up, but it's how you got there that really makes the biggest impact on the plan and the biggest ultimate defense. If you find yourself in a situation where you're getting challenged. Another thing too is we've seen a lot of our clients getting these excessive fee questionnaires when they're re-upping their insurance, and they're not sure necessarily how to fill it out. I had one client sort of offhandedly send it to me and say, "Hey, could you help me with some of these answers? I've spent so many hours on it and I'm struggling with it." And I said, "Yeah, I'll fill out the whole thing for you." And we have all the information in the process for that client to fill out all the when's the last time you benchmarked, what are your fees, when did you last have a reduction, what's your process for selecting investments. They're very specific on a lot of different topics. And the client said, "Oh my gosh, I actually think I misstated some of the things in my draft." So it's making sure that you're not creating red flags inadvertently as you're trying to do the right thing, even for your plan.
Yeah, those questionnaires have really gone from maybe 1 or 2 questions to sometimes 15 questions now. That is a direct result of the litigation because insurance companies aren't wanting to pay out. So they want to make sure all of these different plans that they're defending really have that in place. And we've now, I think we help almost all of our clients now with these, at least the ones that get it. I'm sure there's more to come as well. So with that, what do you think is the next wave of legal challenges that we're going to see?
I'd say it's not real easy to predict where your next wave is going to be, right? We've seen everything from excessive fees to forfeitures to socially responsible investments to index versus active target dates. There's all kinds of litigation out there. So I don't know that anyone has the crystal ball and says we know what the next round of litigation is going to be. I maybe wouldn't have predicted that forfeitures were going to show up on anyone's radar. So I think as we look at existing cases, Tussey versus ABB, that was years ago. I think it's a case that a lot of people are familiar with. It was an excessive fee case, and there was almost $22 million awarded in damages. Now, obviously, a very big plan to have those kind of damages. But then we've actually seen more recently a case, White versus Chevron, which was the opposite. They got challenged, but it got dismissed because they had all the right documentation, right? They had the investment policy statement. They had their meeting minutes. They had all of the meetings that have happened. They just have a very good roadmap, that structured discipline and documentation that we talk about so much, and they were able to get their case dismissed. So I think probably the biggest defense and is not trying to get out there and predict, where the next challenge is going to be. It's being proactive, right? It's making sure that you're trying to get ahead of it as a plan sponsor and be proactive so that you're not just sitting back waiting for the challenge and then trying to figure out how you're going to defend it, right? You want to try and get that process down, do everything you can to make sure that you're going to have a process in place if you ever get challenged down the road. And frankly, get help so that you can get back to work. You talked about the fiduciary and the idea that, it's sort of a flawed system in our industry because you put people in these roles with these very high fiduciary expectations that don't have the expertise and don't have the experience to really fulfill those roles. And so it's get help. If you can't do it yourself, hire someone that can help you with it.
You said it, we say it all the time. We say it with our clients, structure, discipline, and documentation. Really kind of walk us through the documentation play and what all needs to be documented.
Everything, right? So I think...
so they should use that court stenographer to take minutes?
Yeah. So I think, you have to be reasonable with it, right? And use common sense as you go through it. But I think, we talk a lot about the idea that if you didn't document it, it didn't happen, right? So everyone hates doing meeting minutes. We do minutes for our clients. I can't say it's my favorite thing that we do, but it's one of the most important. Maybe the least
favorite thing.
Yeah. But it's one of the most important things that we do, right? Because even as you look back at your last quarter, 3 months have happened since maybe we had our last meeting, and it helps refresh everybody. Where did we end up on these topics? What were the action points? It's making sure that you document it so that not only do you document it in case you get challenged, but it just helps everybody continue things forward and make sure that it doesn't just get lost in the mix. Because, we've had meetings, right, where everybody's excited. You walk out of that meeting and then you show back up 3 months later and everybody just got back to work, right, and started doing their daily jobs. And so we want to make sure we're always pushing all of our things forward and connecting those minutes with action points and making sure that we're documenting everything because, it comes down to it. If it's not documented, it's not going to happen.
Oh, and those clients are usually the best to be 338 so that we can just keep moving forward for them. So with that, in that level of documentation, one of the things I know we've seen with our clients is they get these reports. We try to take them through and highlight any of the kind of blinking, warning lights within our report, whether it's a watch list or replace. And the record keepers, we really ask them to do the same. But, that's something I think plan sponsors need to know too. We talk about red flags, but you also don't want to have a red flag buried in one of your reports that you then have in your compliance file that you aren't taking action on, right?
Yeah. And I think, the biggest mistake that plan sponsors make is overconfidence. It really comes just down to overconfidence. You and I have both heard so many times, oh no, we're good. Or, we've got that covered. Or, even, well, we haven't really had any complaints. So, I think we're going to just, pass. And overconfidence can really, get a plan sponsor in trouble. Now, we're not saying every plan sponsor out there has, huge issues, or that every plan sponsor is not acting in their employees' best interest or doesn't have the expertise. But it's really along the lines of, checking yourself and making sure that you're not in that overconfidence boat. And the example you provided, the idea of reporting versus advice. So you get these reports and one fund has a skull and crossbones next to it. And then this other fund has sunshine and rainbows. And it's like any reasonable person looking at that would say, all right, well, I'm going to replace skull and crossbones with, sunshine and rainbows. But that's not
You're
advice.
Making an assumption?
Yes, right. That's an assumption, right? So it's the idea that it's not advice. Advice is what you need in order for someone to be a fiduciary and someone to protect you. But the other is just reporting. And reporting, there is no liability on the person that provided you that reporting. And so you're not protected as a fiduciary. So it's that overconfidence and sometimes just misunderstanding in what you're even being provided.
Can you give us some specific cases maybe where documentation came into play?
So we've seen it more lately, right? So 3 cases: Prime Healthcare, B. Braun, and Milliman. So all 3 of these were cases that were successfully defended and really dismissed because they had all the building blocks in place, right? They had the right roadmap, the right process. And so they had the right playbook that got them to a place where when they were challenged, they were able to successfully defend it. And what's even been even more interesting, I think, about these isn't just that they were able to get it dismissed or be defended. It's that the courts are starting to take this position that when you're bringing up these experts, the litigators and those that are challenging these retirement plans, bring up specialists and put them on the stand, the courts are actually dismissing them as specialists, but because they're coming there from an outcomes-based perspective. So you sit up there on the stand and you testify and you say that they didn't make the right choice in the end, and that's an outcome, right? You don't have to have the best fund. You don't have to have the lowest fees, and you don't have to have the best outcome. You just have to have a reasonable process for how you get there. And so the courts are really starting to press that issue to say it is so much more about the process than it is about the outcome. Now, we want to have a good process and we want to have good outcomes. I don't want to say that we're not looking for good outcomes.
But we're not expecting them to be fortune tellers. We're already asking them to be fiduciaries, right?
That's right. And you asked earlier, where is litigation going to go? And I don't have the crystal ball. I have no idea where the next wave of litigation is going to come from. So just like you don't know what Fund A is going to be doing 5 years from now.
Right.
So the important part, and the courts are starting to notice this, and really going against experts and saying, you're coming at it from a results-based perspective. We want a process-based. So I think, we talked about structure, discipline, and documentation. That's our playbook for how we get our sponsors to where they need to be.
That's great. Well, let's jump then into fees. We've talked about fiduciary. Let's talk about fees. I think, our makeup friends, Estee Lauder, I think, probably have one of the most expensive lawsuits. Not necessarily what they had in terms of payout, but they had breach of fiduciary duties, that excessive fees with record keeping and administrative costs. Now, they only had to pay out about $975,000 only, right? But this case went from 2014 to 2024. That's almost 10 years of dealing with attorneys. Now, if people are wondering why this litigation is going up, that might be part of it. These cases are taking a long time and they result in a lot of money. So I think we can all agree that it's problematic, but what are some of the most common mistakes that plan sponsors make when evaluating fees?
So I said it before, overconfidence. And, we've really seen, a lot of those kind of evils of the past, right, are going away. 408B2, that regulation that came out years ago that now requires full fee disclosure. No more, your plan is free, but we're not going to tell you why it's free or how it got to be free. So I think
nothing is free.
Nothing is free. No, we all know that. And I think, intuitively people know that things aren't free, but it's the overconfidence in fully understanding your fees. So maybe you know what your fees are, but how exactly are they calculated? How exactly are they collected? So are your fees calculated pro rata or per capita? Is it an asset-based fee? And then
can you explain for anybody who might not know what those two terms mean?
So let's say there's really two basic ways that a plan provider is gonna calculate your fees. Asset-based, so it might be 10, 20, 30 basis points, a fraction of a percent against the assets of your plan. Or they might say that it's a per participant fee. So we're going to charge 50, 60, 80, whatever the number is, dollars per person that is in the plan with an active balance.
Okay, so which one is the right one, which is a question we get asked all the time.
That's right. There's not a right answer, right? But the answer is understanding it, right? Understanding how is it calculated? And then on the flip side, how is it being applied? Because we could get in all the mathematics and all the weeds of it, but suffice to say, if you're saying, all right, we're going to calculate the fee on a per head basis, and that turns out to be $10,000, but then we're going to apply it pro rata, meaning that if you have 1% of the total balance of the plan, you get 1% of the fee.
Okay, so I'm seeing my committee members as you're going through all this. I understand this. This is something we get excited when we find better solutions for. But this is about the time, especially some of my HR professionals kind of roll their eyes and look and are completely overwhelmed. So for anybody listening to this that just is like, what? Swirl information. I don't know. I don't want to be responsible for this. What can you tell them?
Get help. We that's what we do, right? But I think, joking aside, I think it comes down to, spending a couple of minutes. I know it's painful going through the weeds of it, but it's having a good illustration that shows you what your options are, both how it's being done and how maybe it could more reasonably be done.
And who can they go to for this? Do they go, if they're looking at their record keeper fees, do they ask their record keeper to provide that information?
So when it comes to just the facts, right, I think, yes, you can ask your record keeper to get the facts, right, on how is our fee calculated, how are we currently applying it if we're having our employees pay for that fee, and applying it to plan assets. You can get those facts. Now, understanding the facts is maybe something that's a little bit different. And that's where we say, if you can read all of those notices and you can read all of the disclosures and have absolutely good clarity on all of it, then great. If you don't have absolute clarity, then get help and go outside of your firm. And, when we'll get into, benchmarking and things in a little bit here, but I think it's just making sure that you get help to really fully understand what those fees are.
By getting help, I think one of the things we've learned with working with our clients is that a lot of them don't completely understand all of those nuances. And so having the advisor like ourselves or the record keeper bring that in and actually have a training with the committee seems to be a really great way to help drill down those specifics, because even from year to year, as you do these, they might not remember because they're not focused on this every day. This is not the priority of their business. They have a business to run.
Sure.
Right.
For sure.
So really, they keep saying fees and fees and fees. How much does this really impact the participant in the overall income outcome of the plan?
So, of course, fees are critical. They're absolutely critical in every aspect of our lives, right? It doesn't matter whether it's your interest rate on your mortgage or how much you paid for your car or whatever it is. Fees are critical. And so when it comes to accumulating money towards retirement, the important thing to remember is the first dollar that you put in is the one that's going to be worth the most whenever you retire, whether that's 10 years from now, 20 years from now, 40 years from now, you're earlier in your career. So imagine if instead of putting in $1, it gets knocked down to 90 cents, or it gets knocked down to 80 or 70 cents. So that dollar that you're putting in, when you apply a fee to it, the amount of fee being applied to it has exponential impacts as you go down the pike. Now, fees are necessary. Again, nothing's free. So it's okay to have fees, but it's very important to understand what are those fees, and it can have a very big impact on everyone. And anyone who's a plan sponsor that's listening to this, you're a participant too. So those fees are affecting how much money you're going to have when you get down the road. So by having the right processes and having the right evaluations and making sure that your fees are reasonable, all of those things will ultimately benefit everyone in the plan to have better outcomes for retirement.
But when, you have an advisor, they put it into the plan, that should be it, right? Everything passed mustered when you put it into the plan, the fees should be fine, right? Because fees never change, right?
That's right. That's right. So I think, when it comes down, it's, we'll move into, talking about benchmarking, right? So I think it's very, very, very important to benchmark those fees. They do change over time. Hopefully, if your plan is growing, your fees are going down because you're getting more economies of scale.
Well, and especially the fund fees. The record keeping, they have gotten to be pretty good at bringing that information to you, as we've really brought their fees down over the years, over and over again. But the funds are the ones that I feel like are too ever changing. You have to we have to look at them on a quarterly basis really to keep up.
Sure.
Right?
Sure.
Okay. And so when benchmarking, we're looking at that record keeping aspect. Okay. We talked about it before. So do you have the record keeper benchmark their own fees?
So that's one of those funny things. All the record keepers out there offer the service to benchmark their fees. I always find that a little curious, just because, hey, lo and behold, look,
conflict of interest
right.
there.
We benchmarked our own fees, and the results that we gave you are that we're, right in the middle, or we're right in the X percentile, and it's a justification of where that fee is. Now, I'm not saying every record keeper is out there, just trying to justify their fees. We've seen them do these benchmarking exercises on themselves.
And I think they use some third parties as well, but it'd be hard to explain to a judge, well, the person we were paying, we let them tell us that they were competitive.
Right.
I just don't feel like that doesn't pass the smell test to me.
And that's why, we've had, potential clients come to us and say, well, we want you to run an advisor search for us. And I'm like,
sure.
Well,
guess who wins?
I said, well, it'll be kind of funny because I'm going to tell you what the results are going to be. We're the best solution out there. So we don't run advisor searches because that is a conflict of interest, right? So same thing, you want to make sure that no matter what you're talking about, benchmarking fees, doing RFPs, whatever the situation is, the person that is doing that search shouldn't be one of the folks that ultimately is involved in the outcome.
Well, in all of these, ERISA being the largest law on the books is always so crystal clear, and it says reasonable fees. What exactly does reasonable fees mean to make sure that you don't end up in one of those lawsuits?
Right. And of course, we've both been asked that question repeatedly,
over and over.
Whether it's in conferences or whether it's by clients. There is no definition of reasonable, right? You just have to be able to justify why your fees are what they are. Are you getting the right value for those fees? So you don't have to be the cheapest. If you get, let's say, 5 quotes, you don't have to look at it and go, all right, we're going with provider A because they're the cheapest. If provider B, C, D is a higher fee, but is going to give you better service, more employee meetings, on-site review with your account manager. It could be additional services that you very much need. Maybe you have a complicated plan. You've got 5 different companies that are spread across the country, and you need to be able to do all the different cross-testings and different just specifics of those plans that need someone that has a little bit more service and might have a slightly higher fee. Talk about cars, the difference between buying a Lamborghini or buying a Honda. Hopefully there's a little bit of additional value or something that comes with paying for a very expensive car. It's that same kind of concept. And what are you going to use that car for? So what are you going to use that provider for?
Well, and I'm guessing if you're trying to make the Lamborghini seem reasonable, you probably should have some documentation to go along with it to explain your thought process. If you have to drive 110 to work,
right.
You're going to need the Lamborghini, right?
Right. So I think it's just we just say it over and over again. It's all about the documentation. It's all about the process. It's being able to show that there is a reason that you are where you are and that you're paying the fees that you're paying. So just saying, well, I don't know is probably the most dangerous answer that you can ever give. You don't want to be in a position to be back on your heels to say, I'm not really sure why we're still here. I'm not really sure why our fees are what they are. Or,
we haven't looked at them in 10 years.
I don't know when
plus.
the last time we did the review of our fees were. So
I think that reasonable, if you can show that it's competitive in the marketplace and you're getting the value, I really feel like, that's kind of the guidance we've given a lot of our clients, is just that competitive nature. You're not so expensive, and, the lowest is not always the best, especially for your culture. How often should you benchmark? That is the question I feel like we get on a daily basis.
Yeah. And of course, when we're doing conferences and workshops, every single one of those workshops, someone's hand goes up and says, how often should we be benchmarking and documenting? Industry average, I would say, is about every 3 years. It's a good idea to take a look.
Does that mean you have to transition every 3 years?
No, doing a fee benchmarking doesn't at all mean that you have to transition to a different provider, right? It just says, all right, we're taking a look and saying, are our fees reasonable based on where the market is? I'd also say benchmark anytime you have a plan event. Are you divesting, part of your company where you're losing some employees, acquiring another company? Those plan events, absolutely, you want to do a benchmarking.
Now, benchmarking, because I also get this as a question, is benchmarking really doing an RFP? Because I don't know if you've noticed, people do not like to do RFPs.
No, you can just do a benchmarking on fees alone, and without going the whole way out to an RFP where it's the encyclopedia of information. We actually have a great process called Invitation to Compete. It's a patented process that's a kind of a great blend, very easy approach that puts the focus on your plan sponsor, on you as a plan sponsor, rather than going all the way to a full RFP or just saying, give me your best price.
Let's jump into the Invitation to Compete.
So there's kind of two sides to really any search, right? You've got plan services and you've got plan fees. Every plan sponsor that I've talked to, if they want to evaluate services, immediately goes to RFP. Our patented process of invitation to compete is, we work with that client and say, tell us what the pain points are, right? Yes, we're going to do the fees. We're going to look at that. But, again, talking about reasonable fees, you have to be able to justify why the fees are what they are. So our process is give us a couple of the pain points, give us a couple of things that if you had a perfect world scenario, no provider out there is perfect. Let's just talk about what those pain points are. And then we put the focus on you. It's not just going out to the market and saying, tell me all of the things that you can do. Tell me about the white space on your web pages and about your amazing planning tools and all of the things that you can do for a plan sponsor. It's saying, my plan sponsor needs this. These are the things that they're worried about.
Right. Because, we talk to a lot of great record keepers all the time, but there usually is one record keeper that's going to be great for you, right? That has really the niche or the focus that's going to line up better with your organization. So I really do think Invitation to Compete has been able to match those people together. Maybe we didn't we joke that it was like it was kind of like a dating service at the beginning,
dating,
speed dating. That was what we were joking that Invitation to Compete was like.
Right.
Great. So what about the capabilities of the record keeper? Are there any problems that come up that you can't address in that process?
No, and I think one of the neat things about Invitation to Compete, when you're talking about what are the problems that you have as a plan sponsor, and that's a pretty easy conversation. Most sponsors know where their pain points are, right? We don't get enough service, we don't ever hear from anyone, or our testing always takes too long, or whatever the situation is. When you, and a lot of plans have very unique kind of twists and turns. I talked about whether you have 5 companies across the country,
multiple divisions,
all of the things that make record keeping a little quirky. So it's going out to the market and talking to a handful of different providers with those pain points. And then you can even stay with your current provider, but implement some of those great ideas that you're getting from other providers. Now,
creative solutions from a lot of different experts.
That's right. It's and also then along with it comes the competitive bidding, right? It's the competitive prices, and you can leverage those other prices and those other capabilities, even with your current provider, to get the lower price, get better service, and not have to move your plan.
So, what is the ultimate goal? What should they really look at from doing these processes?
We talk about documentation, of course. It's always great to document that you've just looked at the market. Lower prices are great. competition is better. So it's getting those firms to compete for your business. And, you are the client, and you can go out to that market and say, we want to know what the best price is for the right service. So we've documented that our fees are reasonable, and we're doing our due diligence as a fiduciary.
Actually, I'm really excited how well Invitation to Compete, every client we've used it with has really enjoyed it and been like, this is the easiest RFP I've ever done. So hopefully we can do that for more people as well. Well, let's transition and get to the final F word, right?
So fear of litigation, right?
Yes.
I think any plan sponsor has a little bit of a fear of litigation, right? It's a hassle first and foremost, but it can also be expensive. So, Sara, give us a case study that best illustrates why fiduciary oversight is so important.
Well, I don't know that there's one specific case. Over the last, since about 2016, we've had 526 cases. We actually had such a huge ramp up in 2020 of over 220 cases that the following years, we didn't have as many, but it's because the law firms that were focused on this already had so much on their docket. It wasn't because it was losing momentum, which at first we looked at, and that was not the case. And as we talked about, we continue to see them do these laundry lists. So even if maybe you're documenting one aspect, you really understand how your contributions and all the administrative aspects are working. If you don't have a good investment policy statement and looking process for your investments, they're gonna hit you in different areas. And just like the Swiss Re, they're gonna have all this laundry list. And if your processes don't document all of it, that case is going to move forward and have that increased litigation.
Right. So give us a few examples of plan sponsors who kind of failed at their duty for prudence and for monitoring their plans properly, and give us some numbers. What are some real financial impacts for those plan sponsors?
Sure. And I want to point out too, again, this is a flawed setup because you just said failed. And that word kind of hits home because I know these plan sponsors. We love our clients in industries all over the country, and they're not doing this from neglect. They're not doing this out of malice. This is just because maybe they don't know. And these legal documents that set up these plans are hard to read. Even for people that do it all the time, not everybody's a trained attorney that can do that. So one of the situations we came across was Danberg versus Lametta. Collision. They were a $9 million plan. I always hear too, hey, we're so small. We're so small, litigation's not going to affect us. $9 million and 114 participants. And they got excessive fee for record keeping and breach of fiduciary duty. And this is one where they were just scrutinized. And the specifics that caused them so much really had to do with the length of time too and the legal expenses. You just don't want to be drawn into this. It just can weigh down. And we're seeing more and more on smaller cases as well. So it's not just those mega cases anymore.
So we see all these headlines, right? And we're talking about all these different examples and all these different cases and the dollars and all of these scary things. So what does a plan sponsor do with that information?
It's kind of like a roadmap. You just have to say, okay, every time you see one of those legal cases come through, see, okay, what did they do wrong? That is now your Cliff Note version of what you need to check in your plan. Excessive fees. Okay, well, I know our record keeper just brought the fees and discussed it with the committee. I know our investment advisor looks at our fees quarterly. Okay, I think I have that checked, but is that listed in the minutes? Okay, let's just go through and do that. And if your job is too busy to go through that, send an email to your advisor. I get emails all the time. Hey, I saw this article. I saw this come up that this is a new suit. Are we doing this? And luckily, because we have structure, discipline, and documentation, more times than not, I can say yes. But you know what? Let's re-review it. Let's use this as part of our next fiduciary training, which is another aspect you can ask your advisor to help you with, is bring these type of lawsuits, explain it, and have that be part of your fiduciary training with your committee.
Yeah, and bringing on an advisor like SWBC, I think it's important plan sponsors know that doesn't require a conversion, right? Going outside of your current record keeper and your current structure doesn't require the pain, right, of doing conversions. But if you need that help and you need to look at some of these cases and say, I need maybe a little bit of advice around how do I use this productively, there are folks out there like SWBC who can help.
Yes. Specifically SWBC, right?
Right, that's right.
But really, not only is it something that, we'd love to help you as an advisor, but if you don't have the expertise, ERISA does say that you're responsible to do that. And they do continue to go forward and say you then have to monitor and look at the due diligence. That's hard to say right at the end of the day.
Due diligence.
Due diligence on all of your fiduciaries. And that is one of the things we help our clients do as well. We actually provide them an annual folder that gives all of those different aspects, our services, our insurance that backs everything that we're able to do, all of those different components that they need to build out their compliance file.
That's right. So if a plan sponsor could implement just one risk mitigation strategy today, what would it be?
Well, that's an interesting thing to ask. There's not just one thing. And I think that's what these suits are saying. You can't just focus on one thing. You really have to go through the whole process. And that's why you need that, again, structure, discipline, and documentation. I feel like we could have a drinking game at this point, but it's so important because you leave yourself vulnerable, right? You can, if you go out and do if you're building a house and you do all the safety things and are building the right thing, but the person that's building your house forgets to put on their hard hat and gets hurt, you've got to cover your bases and make sure that you're protected in every different angle and every way.
So, even just staying away from strictly the fear of litigation, how does a plan sponsor keep up with all of the changing industry trends and changing regulations? 408B2 came out years ago. Then we had Secure Act. Then we had Secure 2.0, which was huge and lots of different provisions. So how do they keep up?
And they were even whispering about Secure 3.0. I'm like, we haven't even gotten halfway through Secure 2.0. You keep up with your advisor and your record keeper. Those are really things. You have hired these professionals to bring you this information and to keep you up to date and compliant. That is their job. And you can ask them to do that job for you. Really, there are so many things as a fiduciary that you can say, I need you to handle this for me. I need you to set up these agendas. I need you to bring this information to me to make sure that my committee is compliant every time we meet.
And I'll say shameless plug for SWBC. It's the no conflicts of interest and getting a full fiduciary commitment, right? It's something we've always done, and we've talked about checklists and different things. Whether it's SWBC or someone else, I think it's important that plan sponsors know those points, right? Get the fiduciary commitment. Make sure you get rid of those conflicts of interest. So I know we covered a lot in this discussion, in this playbook discussion. I hope that everybody found this to be beneficial and listening in on all of our discussions around the retirement playbook. We talked about fiduciaries and really how the responsibility of a fiduciary is so important, yet it's put on people that don't necessarily have a lot of background to support that fiduciary responsibility. Fees, and everybody knows fees are important, but understanding fees and how they need to be reasonable and how do you benchmark. And then a fear of litigation. There's always a concern that you might get challenged for your plan. So we want to make sure that we can sort of prevent some of that fear or help assuage some of that fear the plan sponsors have around the potential for litigation.
And, these topics are important. You want to give your participants a really wonderful plan. One of the reasons is because you're one of the participants. You want to have this and be able to deliver such a great benefit. And there is a lot of responsibility, but with the right resources, hiring the right people, you can really make this a great experience that doesn't have to feel so overwhelming.
So if you have any questions, you want to dive deeper into any of these topics, we'd really welcome the opportunity to talk to you as a plan sponsor and go through some of the things and some of your needs and provide you with a free consultation. We have a resources page that we'd love for you to visit. Lots of things out there that talk and dive into these different topics in a lot of detail. And again, we would really welcome the opportunity to talk to you a little bit more about your plan specifically.
Yeah, we can always assess your structure, discipline, and documentation. And if you enjoyed these videos, we also have a what if series that dives into a lot of these topics, but then really has more detail in each one of them if you want to look into each item more closely.
So thanks for listening. Until next time, make sure that you stay informed, stay proactive, and remember that knowledge is absolutely your first line of defense. Thank you.